that make it on time. It's a wonderful pleasure to be here with all of you today to talk about the as-is contract and how to win deals. Um, this actually got updated now, so we'll change that. Welcome everybody to today's training on understanding the as-is contract and how to win deals. My name is Ricardo Teran. I am the co-founder and director of business development of Folio Title in Florida. And what we're going to try and do today is break down this wonderful tool called the as-is contract. And we're going to talk a little bit about how you can use it to win some of your deals. Those of you that have worked with the as-is contract in the past know that it's pretty extensive, it's pretty complex. Most of the realtors I meet have actually never read it completely, which is something I highly recommend you all to do. And so what we've decided to do as we've evolved this course is we've broken it down into a couple of sections. Today's course is going to be on the basics of the as-is contract. So there's going to be a lot of things that we do not cover that we're going to leave for a second training for kind of more advanced users. So this is a great starter course for those of you that just want to understand the basics. Make sure you master the basics. We're doing today in English. We will do another one later in Spanish. So thank you for joining us today. My name is Ricardo Teran, and as I said, here are some of our coordinates. I wanted to invite all of you to please scan that QR code and leave us your information to ensure that we can send you the video of the presentation after we edit it, and we'll send you the presentation slides as well. So you guys will get that by signing up into that QR code. I also wanted to invite you guys to follow us on social media at Folio Title, and my username is at Ricardo Teran, or sometimes I'll post some interesting content, okay? This presentation is not legal advice. It's very important that nobody acts or tries to act like an attorney, and that we, suggest always to our clients to seek legal opinions. This webinar should not be substituted or taken as legal advice. We're not going to cover every detail of the as-is contract, as I said. We're not covering things such as FIRPTA and permit disclosures. I'm happy to take questions in the Q&A, but as I said, we're dividing it into kind of a basic and then a more intermediate class where we'll talk about some of that. We have a pretty full agenda today. We're going to talk about what is the actual FAR/BAR as-is contract. What are some really important tools that you're going to need to properly fill out those contracts? Understanding what a legal description is, understanding the buyers and the sellers, personal property, everything having to do with the price, the deposits, the financing, and collected funds. I'm going to show you a quick calculation of how to do a cash to close. Calculating timeframes in the contract. And what are those key timeframes? We're going to go into the financing contingency, which is paragraph 8 of the contract. We're also going to talk about occupancy and possession as well as assignability. We'll go through some additional terms and why they're important. And then we're going to highlight some of the key addenda. And finally, we'll go through a very frequently asked question, which is, what is closing actually? When does a closing actually occur? And when do keys need to be provided? And we will wrap up with the role of the realtor. Okay, so we got a pretty heavy agenda today. What we're not going to cover closing costs today. We've done a separate course on closing costs. Some of you may have seen the English version. Some of you may have seen the Spanish version. If you have not, and you want a copy of those recordings, please let us know. We're going to actually be publishing them on YouTube very soon, so you'll get notified about that. We're not going to cover all of the addenda. We're not going to cover the post-closing occupancy rider. We're not going to be talking about FIRPTA or international closings and remote online notarization, and we're not going to cover buyer paid compensation in the contract. We're going to leave these for part 2, okay? If you have questions, please pop them into the chat, and we'll do our best to answer them before the end of the recording, okay? Before the end of the session. All right, so let's get to it. What is the FAR/BAR as-is contract? So the FAR/BAR as is contract is a form contract that was created by the Florida Association of Realtors and the Florida Bar. This initiative began several decades ago when it was commonplace for attorneys to create their own purchase and sale agreements. This generated not only a lot of confusion and frustration amongst realtors and clients, it also increased the expenses of the transaction because each contract was individually crafted. Realtors needed to work a little bit faster. And so and attorneys and realtors obviously cannot write contracts because they're not attorneys. So the attorneys and the realtors got together and said, if we had a baby that we could both agree to be happy with, what would it look like? And so they began a collaboration. They formed a special task force with Florida Realtors and the Florida Bar, and they came up with these contract forms. And one of these forms is the as-is contract. Now, I want you to pay attention to the footnote of the contract here, because you're going to see that, first of all, it's copyrighted, right? So if you're not a member of Florida Realtors or Florida Bar, you technically shouldn't be using this contract. It also has the number 6. This is the version number, right? And the versions of the contract are important because they change, and it tells you the version and when it was revised. Right now, the latest revision that we have is version 6X that was revised last year in the summer to reflect the major changes in the law against certain foreign principles, right? But there's been previous updates in the last couple of years that have made some very significant changes to the contract form. There are several different versions of Florida Realtor contracts. There's a CRSP version. There is a Florida Realtors, Florida Bar version that is not as is, which we'll talk about the as is nature in the inspection clause. And the one we're going to talk about today is this one, the Florida as is residential contract. Okay. Now, what are some of the key tools for properly filling out this contract? So if you are an Avanti Way agent, you have the benefit of having the forms too in AVEX, right? AVEX is where you get the forms, and the artificial intelligence allows you to create a new contract and helps you automatically fill in the contract, right? This is amazing because a lot of systems don't do it, but where is the information coming from and what do you need to know? Well, the first tool you need to know is the property appraiser's office. Property appraisers are county specific. So if you're in a certain county, you want to Google such and such county property appraiser, right? So Palm Beach County property appraiser, Duval County property appraiser. In the property appraiser's office, you're going to get a couple of things. You're going to get the property tax ID or the folio number. That's where our name, we thought of it from, the folio title. It will reference the current owners. It will reference the legal description, and it's also going to give you an aerial, view of the property. Okay. I wanted to share with you guys what some of these look like, right? So this is the Miami-Dade property appraiser's office, right? This is the Broward County property appraiser's office. So if you come here and you type, an address, you should get a property card, right? And here in this property card, you can see the folio number here, and you can see who the current owners are referenced, right? When you see the words TRS, that means trust, right? That means trust. And over here, you have a legal description, right? We're going to talk about the legal description soon, but you have a legal description here. What you also have in most property appraisers' office is you have a link to the property taxes of the property in question. So all property appraisers' office will link you to the tax information for that property. You're also going to find in property appraiser's office the historic sales information, right? You're going to find when the properties exchange hands, they were legally transferred, and for how much. And if you click into the OR book and page, OR meaning official records book and page, you can actually find a copy of the instrument, usually the warranty deed, that transferred the property. So these are just really useful links and an easy way to go out and find what you're looking for to fill out your contract. Why? Because a contract is going to require a lot of these fields. Again, if you're using AVEX, these fields are automatically filled out for you. Now, another tool that's really interesting is the clerk of court. This is where official records are stored, and they're also county specific, right? Here you can find things such as prior deeds, right? Which is what we just did. We found this prior deed that transferred the property to these owners. And the prior deed is going to help you confirm who are the current and prior owners, as well as the legal description. You're also going to find in the clerk of court, in the official records, you can find mortgages and other official documents related to the property and property owners. So if there is a lien, for example, that is filed against the property of the property owners, they need to go and they need to register it in the clerk of court. Now, from the property appraiser's office website, you're also going to be able to reach the tax roll. You guys saw how I did it here, where you go to property taxes. In Broward County, it's pretty much the same, right? You'll find the property taxes, right? So that's another key tool. Now, Sunbiz is another tool that you need to know about. This is the official state registry of companies, right? So if you go to sunbiz .org or .biz, you can search records, and here you can find the name of the company, right? You can find the name of the company. So for example, if you search for Folio Title, you can find, Folio Title and all the information of different companies named that way. So if you're working with clients that have an LLC, this would be one way that you can find that company. Lastly, many of you use IMAP, which is linked to the MLS. IMAP brings in a lot of the information that we're talking about. I always encourage people to use, if they use IMAP, to go out and validate the property appraiser's records. Now, let's talk a little bit before we get into the contract of the legal description, because this is going to be important for the contract. Now, the legal description very precisely identifies and defines the boundaries of the property. From a legal standpoint, what somebody is buying or selling is what the legal description says it's going to be. So, some legal descriptions are extremely long and they don't fit in the contract. This is why many contracts don't have that legal description filled in. And we'll talk about this in a bit. But the actual legal description is essentially contained in the prior deed. Here, the legal description would be all of this, right? This lot 26A, block 1, Fontainebleau Park West Villas, and it goes all the way till down here, right? Some legal descriptions are more than a page long, so you're not going to be able to type all that in, right? Now, the county references key components of the legal description. So theoretically, if you copied and pasted this into the legal description of the contract, which I'll go to now, this is where you would do it, right? So in AVEX, you guys get, filled in information that you write, including the property tax ID and the address, right? According to the guides that I've heard from Florida Realtors and Florida Bar, you want to ensure that you have two of the three ways to describe the property, right? One is the street address, which is actually a postal address. The one who gives you the address is the post office, right? You also have the property tax ID. The one who assigns a property tax ID is a property appraiser. And then you have the legal description. Attorneys, I think, would always say that the legal description is the most important one. But because they don't always fit, many times they're blank. So if you fill out a contract and you have the address and you have the property tax ID, you should be good. But I think it would be a best practice to ensure that you at least can reference the legal description in the property appraiser's office, okay? So that's everything that has to do with the legal description. In terms of the rest of paragraph 1 of the contract, in addition to the street address, the county it's located in, the property tax ID, and the legal description we just talked about, we're talking about personal property that may be included in the contract, okay? So the personal property section of the contract essentially says that whatever is owned by the seller and exists on the property as of the day of the offer, right? Those things, if they exist, are included in the offer, right? Your range in your oven, your refrigerator, your dishwasher, your ceiling fans, etc. What is not on this list is washer and dryer. So anything you need to add, for example, right, like washer and dryer, or maybe there are security cameras, for example, that are installed, you would add in this other personal property section, okay? You would add here in the other personal property section. And then we'll talk about more in a sec. If there are items that are excluded in the purchase, here is where you will write them, right? So we'll talk about this in a second. Now, one of the most common problems that we have with contracts is the way that the buyer and the seller are identified in the contract, okay? This is the literally the first and the second line of the contract, okay? And so in the seller section, we want to make sure that we are putting the sellers of record, right? The sellers of record officially come from the prior deed, right? And the property appraiser's office references who the owners of record are, right? In this case, it would be these people are the owners of record, right? Now, many times what happens is that you will have an owner that does not appear here and they freak out. And then maybe you find a deed down here and it says that there was an error in the recording. And so maybe because of the error, the property appraiser has not updated who the owner is. This is actually really annoying and more common than you think. So you know, if you want to be extremely thorough, you know, Avex imports the owners of record. You can just come and double check here in the property appraiser's office and in the prior deed, okay? Now, many times you're going to find the words EST or estate of. That means that the individual who was the owner on record is deceased. They died. And the ownership of the property goes to their estate, okay? Now, when you see EST or estate, it means that to be able to convey the property, to transfer the property, the personal representative of the estate is the one that needs to sign the documents. Sometimes you will find that the personal representative of the estate has not been assigned yet. Sometimes you'll get maybe a son or a daughter or a spouse or a brother or a sister who signed the documents on behalf of the estate. When you have an estate, you need to make sure that you are coordinating with the listing agent to ensure that the person who is going to sign on behalf of the estate has the legal authority to do so. You will not be able to establish that legal authority. That is for the title company and for the attorneys. You just need to make sure that you bring up that if it's the estate, that they have the personal representative assigned, okay? Now, I have seen on many contracts that the seller, when they write the seller's name, they write owner of record. That is not a good practice, and I do not recommend that you do a contract where it says owner of record, all right? Now, there are some contracts where if you go into some properties where if you go into the property appraiser's office, the owner's name is redacted. You cannot find it. It's blank. You cannot find the property. That usually tends to happen when there are hidden records for public servants and law enforcement officials, right? So if you are a police officer or you're a judge, for example, and you're selling your property is probably hidden in the public record. You won't be able to find it. Okay. Now for buyers, the way that you write the buyer's name here, this is the way that they're going to appear on title and the warranty deed. Can we change it at the end? Yes, of course you can change it at the end, but it's a lot more work. So one suggestion that I always provide is that you write the names as they appear on the ID and you verify that that's how they want to take title. So for example, it's very common with many Latin Americans that we have four names. But here in the United States, we usually only use our first name, middle name, and last name. So we have three names. So maybe you were baptized or Christian with four names, but you've been using in the United States on your IDs three names. That is probably what you want to write in there. If you're going to use a driver's license, if you're going to use a passport, some people use four names. You need to verify this with your buyers. But the closer you get to the ID, the less issues you're going to have throughout the transaction and later when we record. Now, when you apply to a mortgage, you should apply with the exact same name that you put on the contract, right? So if on the contract I put Ricardo Terran and on the mortgage I filled out Ricardo Jose Terran, it's just going to be much easier if on the contract I came out as Ricardo Jose Terran or if on my mortgage I applied as Ricardo Terran as the contract. My ID says Ricardo Jose Terran, and that is what I would use, and it would make it much, much simpler. Now, if you're closing under a legal entity like an LLC, you have to, as a realtor, ask the buyer, is the company formed or is it not formed? If the company is already formed and you can find it on Sunbiz, or if it's not a Florida corporation, because Sunbiz is a registry of Florida corps, if it's not on Sunbiz, they will give you documents as to the name of the company. Um, you should use the name of the company right there into the buyer's line. Now, if it has not been formed, you could use the individual name and you can add the words and or assigns. So let's say I want to buy a property, an investment property, and I do not have a company assigned. I could write Ricardo Terran and or assigns. And that means that if I get the contract, if I win the contract as the buyer, I can create an LLC during the contract and assign the contract as long as the contract is assignable in paragraph 7. All right, we're going to get to paragraph 7 a little bit later, but if you write the name and or assigns and you check off assignability on paragraph 7, you will have no problem assigning it. Back to personal property, we talked a little bit about these. Section 1D is items that are included in the purchase. Section 1E are items which are excluded in the purchase. Remember that paragraph 1C includes all existing improvements and fixtures. That's what you're buying. So for example, if you have a chandelier that has been in your family for 3, 4, 5 generations, that is a fixture. If you are not going to include the chandelier in the purchase, then you need to exclude it. Another common one is speakers, right? There are speakers that are fixed, right? Maybe you want to take those speakers with you, right? If you have speakers, let's say outside in the patio that you installed, maybe you want to exclude them, okay? So these are important paragraphs to understand as you kick off your offer. Now let's talk about paragraph 2, the purchase price and the closing. We're going to break this down. You know, here you basically write the purchase price and then you are asked for an initial deposit, right? One of the most frequently asked questions I get is, what is a good initial deposit? How much should my client deposit? There is no right answer. This is a negotiation. This is how much the buyer feels comfortable putting at risk and essentially making a part of their offer. Now, AVEX's artificial intelligence will suggest to you a level of deposit, but at the end of the day, it's negotiable. This section also includes a time frame for deposit. So you have to be really careful because this says if you don't fill anything out here, by default, it's 3 days after the effective date. It's 3 days after the effective date. We're going to talk about calculating timeframes and effective dates in a little bit. Okay. in terms of escrow agent versus closing agent, this paragraph asks you who the escrow agent is going to be. The escrow agent is that neutral third party that holds the deposit in escrow while waiting for the transaction to close. Many people make the mistake that the escrow agent has to be the title company. The escrow agent does not need to be the title company. You can have one escrow agent and you can have a totally separate closing agent. The closing agent is what usually they call the title company. The closing agent is the one who will clear title, close the transaction, and give you a title insurance policy. If you are in Avanti and Avex, you should probably keep the default, which is Avanti Way. Why? Because brokers have certain tools available to them in the case of escrow disputes because they have access to FREC, which closing agents and attorneys do not. Those disputes go straight to court. And so it's usually a little bit cheaper and a little bit faster to go if there is an escrow dispute if you're using your broker. Now, many brokers do not hold escrow. Actually, I would say most small brokers do not hold escrow, and even some very large brokers don't hold escrow, including for rents. So the escrow agent and the closing agent can be different, and you can use your broker. In terms of additional deposits, we really encourage additional deposits because it reconfirms the buyer's intent to purchase. I have seen over the years that putting additional deposits sometimes comes down to where you got trained or what broker trained you, or if you got training in the Association of Realtors. I think as a practice, putting two deposits is a good idea, even if it means splitting your first deposit into two, right? Or maybe let's say you're going to give a total deposit of $10,000. Maybe you put 2,500 in the first, 7,500 in the second, right? 25% in the first deposit, 75% in the second deposit. How you decide to divide them is really up to the buyer. Okay, but the second deposit is a good idea. Now, in terms of financing, we usually encourage people to put a percentage of financing, right? This is not the down payment. This is not the down payment. This is how much you're actually going to finance. So if you're going to put a 25% down payment, the amount you're going to write here is 75%. Okay. So it's basically the amount of money you will finance. This is an important clause because this is what is going to provide you the financing contingency. Your deal is going to be subject to getting that percentage of financing. And if the bank approves you for less financing, well, this is a protection. Lastly, we're talking about the balance to close. This is a remaining amount of money that the buyer must pay to complete the purchase, right? After subtracting the initial deposit and the financing. In the kind of industry lingo, you'll hear the term cash to close, right? Which is the balance that is required to close a transaction. We usually recommend putting in the word balance instead of a number. Some agents hate that. Other agents accept it, listing agents, but the reason it's convenient is because if you're negotiating the purchase price or the financing or the deposits, this gets very messy. There's a lot of lines that get crossed out. There's a lot of initials, etc. So you could be changing things up here without affecting the balance, right? This amount is typically paid through wire transfer. You could see here that it talks about by wire transfer or other collected funds. Collected funds are those funds that have actually and finally been collected and deposited. That's a lot of words to say. Checks are not collected until many days after the check is deposited because a check can be reversed, right? As can an ACH. You can actually recall an ACH. When you do a wire transfer is the only form of payment that is currently collected, considered a collected fund, right? So the deposits usually the escrow agent will accept the deposit by check, maybe ACH. Of course, they'll accept a wire, but the balance to close for the closing agent, you need to plan to do it in the form of a wire. Now, here's a little formula to calculate the cash to close, right? So if you take the purchase price and you subtract the deposit and you subtract the loan and you subtract any credit that you may get from the seller, and then you add the closing cost, that is the cash to close. Let's say you buy a property for $100,000 and you deposit $10,000, right? You're going to get a $90,000 mortgage. There's no seller credit. So 100,000 minus 10,000 minus 90,000 is zero. However, you have to add the closing cost. Let's say the closing costs are $1,000. Well, you're going to have to send for your cash to close $1,000. Now, if the deposit is only 5,000, you have 100,000 purchase price minus 5,000 in deposit, you have 95,000. If you get a $90,000 mortgage loan, you have a $5,000 balance. You add the 1,000 in closing cost, now your cash to close is $6,000. That is the simplest formula to calculate cash to close, okay? Hopefully that wasn't too fast. Let's calculate time and move on to paragraph 3. Okay, how do you calculate time? Well, let's talk about paragraph 3 first. This is the amount of time where you provide as a buyer for both buyer and seller to sign the offer and deliver a copy to everybody. In other words, here you will put a date as a buyer where if the seller does not sign and deliver the contract by that date, the offer is basically withdrawn. Now, could the buyer accept a signed offer after that date? Sure, the buyer can accept it, but it's up to the buyer. The buyer has a right to also reject it, right? Legally reject it. Usually you would fill in 2 or 3 days here in time for acceptance. In other words, you will usually give the seller 2 or 3 days to accept the offer. Now, any counter offer that is made to you usually has 2 days of validity. In other words, if you send an offer to a seller and the seller gives you a counter offer, usually you have 2 days to reject or accept. Now, the effective date is the official start date of the contract. This is when the last person, either the buyer or the seller, signs or initials the offer that was made or the counter offer. If a seller makes a counter offer, let's say they change a term, they have to initial it to signal that it is a counter offer. For the contract to be effective, the buyer needs to accept that counter offer by initialing the changes and sending it back to the seller. So the effective date is that date where all the signatures are complete and it was delivered. Okay. Now, if you send an executed contract to a realtor, it is considered proper notice, right? So let's say you're a buyer's agent, you send an offer to the listing agent, the seller signs, the listing agent sends it back to the realtor. Let's say that for some reason you didn't see that offer. You didn't see the offer in your email. The clock began to tick the day that they send you the email. Now, could you guys agree to a different effective date? You can, but you need to write it, right? But at the end of the day, this date, the effective date, marks the beginning of the contract's validity, and most of the timeframes in the contract are going to come from either the effective date or the closing date. So this is a really important date to monitor. Now, in terms of calculating time, one of the most frequently asked questions that I get is, how is time calculated in the contract? Is it working days? Is it calendar days? And the answer is that the as-is contract uses calendar days, right? A calendar day in the latest version of the contract means midnight to 11:59 p.m. Previous versions of the contract talked about 5 p.m., which is the end of the business day, but that was removed. My preference is that we do things during the business day, because then you're not running around at 11 p.m. trying to agree to something. So, but the contract allows to 11:59. Holidays and weekends that will fall within a time period are counted as calendar days. We're going to do an example right now to show you this. But if a deadline falls on a weekend or legally observed holiday, that deadline will extend to the next calendar day. Okay, so we're going to do an example to walk you through and make sure we get this right. And we need to understand that the effective date we're going to count as day 0. Okay, so let's say you have an as-is 6 contract and you have a 7-day inspection period, right? 7 days from the effective date. When is the last day of the inspection period? Well, in this example, if the effective date is on Wednesday the 8th, you're going to count this as day 0 and you're going to count 7 days. 1, 2, 3, 4, 5, 6, 7. The end of the inspection date is the following Wednesday. You execute it on a Wednesday, 7 days later is the following Wednesday, right? So effectively, the effective date is day 0. Okay, this is pretty easy, pretty straightforward, right? We counted Saturday and Sunday, so we counted the holidays, right? So you have 7 full days. Now, let's do another scenario, right? Let's say that you execute on Sunday the 5th. Well, day 7 is a Sunday. So the contract says if the deadline falls on a weekend, you move it to the next day. So if you execute on a Sunday, the 7th day, even though it is Sunday, the deadline becomes Monday the 13th. Does that make sense? Yeah? Okay. I only see Richard on video, so I'm using his body language to ensure that it's being understood. So you're on the hook, Richard, for everybody to understand with your body language. Okay. Let's do another scenario. Let's say that we executed on the 13th and we have 7 days. When is the deadline? Well, in this scenario, the effective date falls on a legal holiday. And so we have to move it forward to the next day, right? So you execute on a Monday, it falls on a holiday, it moves to the next day. So effectively, this 7-day time frame, you're actually getting 8, but the deadline is the day after the holiday. Let's look at a 4th scenario. You execute on Wednesday the 15th, you have a weekend, and you have a holiday. Well, they count as calendar days because the deadline does not fall on those days. So you count 1, 2, 3, and 4 are the weekend. 5 is the holiday. 6, 7. So here you have 7 days. The last scenario is if you have a 7-day inspection period that falls on a weekend where the next calendar day of the week is also an observed holiday. If you would have executed on December 17th, 2022, a Saturday with a 7-day inspection period, the 7 days finish on a Saturday, but it's a weekend. So you need to move it to Monday. Monday is the observed holiday of Christmas, which was on a Sunday. So actually the end of the inspection period would be Tuesday the 27th. Right? So in this scenario, you actually, for a 7-day inspection period, you actually had 10 physical days. All right. So hopefully these examples allowed you to understand how to calculate correctly the timeframes of the contract. Okay. What are some key timeframes? We're going to go through some of these. We talked about the effective date. We talked about time for acceptance and counteroffers. We talked about the deposit dates. Okay, remember there's a deadline on the first and the second deposit, right? We also talked about the we need to talk about the closing date, right? The closing date is in paragraph 4. Okay, the closing date is in paragraph 4 at the bottom of the first page of the contract. And basically it says that the transaction is going to close when 2 things happen. All funds required for closing are received by the closing agent and collected. This is why we need a wire transfer, right? We need to have we need to have all the funds received and collected. And the second condition is that all the closing documents that are required have been delivered in their originals, okay? This is why we cannot fund a transaction as a closing agent if we do not have original seller documents. Even if we have scanned copies, we're required by contract to have the documents delivered. Okay, so this is a really, really important time frame in the contract. In paragraph 4, it's called the closing date. Okay, there are many references to deadlines that refer to the closing date, right? So now we've also seen the closing date. Let's talk about some of the dates in financing. Well, sorry, before we go there, we're going to go to the inspection period. The reason I'm jumping around is because I found that there's a kind of certain logic to these contracts. So even though the inspection period is in paragraph 12 and we just jumped from paragraph 4 to paragraph 12, I'm trying to get through all the key contract timeframes. And paragraph 12 has a really important one called the inspection period. In the as-is contract, paragraph 12 says that the buyer may cancel the deal, providing written notice during the inspection period at the buyer's sole discretion. This language, at the buyer's sole discretion, which basically means for any reason the buyer wants, is what makes this an as-is contract. The buyer is taking this property as is, or they have the right to get out. If you don't like something in the that you find in the inspection period and the seller doesn't want to fix it, the seller is not forced to fix it, you can get out. But if you take it as is, unless the seller agrees to fix it. And if you agree to fix it, then you need an addendum where you agree, where the buyer and the seller agree to fix it, right? So paragraph 12 provides us with a key contract timeframe of the inspection period. Okay. Now, this is going to be, the densest part of the training, which is paragraph 8, which is paragraph that has to do with financing. There are some very important key dates here. So we're going to first go through the key dates, and then we're going to go through some of the clauses, right? So paragraph 8 starts talking, it actually gives you 4 options, but the 2 most common ones are these, A and B. Option A, it says this cash transaction with no financing contingency. And I just want to be crystal clear. Paragraph 8A essentially says that the purchase is not subject to financing and that the buyer will find a way to come up with a cash up to the closing table. Paragraph A does not prevent the buyer from getting a loan. The buyer can go and apply for a loan, but the contract is not contingent upon that buyer getting the loan. So if a buyer marks paragraph 8A and goes and they get the loan and the loan is delayed or the loan doesn't close, the buyer is on the hook to pay for the property in cash. Okay, this is important. Paragraph B means that the contract is subject to getting a loan, right? The property is subject to getting a loan, and this is where the key dates begin in this paragraph, right? The first key date is the buyer's purchase is subject to getting a loan within a certain amount of days, called the loan approval period. If you don't write anything in that loan approval period, it's by default 30 days. Okay, by default, it's 30 days. So this is a really important time frame in the financing contingency. The second key date is the financing application date, right? If you don't write anything here, this contract gives the buyer 5 days to apply for financing after the effective date. 5 days after the effective date. So these are 2 very important timeframes that are contained in 8B, which is the financing contingency. Okay. Now I want to give you some more information about the financing contingency. We already talked about 8A. It does not stop the buyer from obtaining financing. It only means that the buyer's deposit is not subject to getting a loan, right? It's exposed. So in a cash deal, the deposit that you put down after you pass the inspection period of the as-is contract, your deposit is at risk if you do not close. Let's go through a little bit more detail on 8B, right? Now, when you're getting a loan for a property, the lender and the property are both being vetted during this loan approval period. Remember, we talked about the loan approval period up here. You have a certain amount of time to be authorized to get the loan, right? What the lender is doing is they're doing due diligence on both the both the borrower as well as the property. Okay, this actually, I apologize, I wrote the wrong name. They should say borrower. Now, the next sentence asks you to disclose a type of loan, right? If you say that you're getting a conventional loan and you get an FHA loan, you technically shouldn't do that. If you are getting a DSCR loan, which is an investor loan, and you want to make the contract subject to that loan, you need to check other and write DSCR or bank statement, whatever the loan may be. If you're getting private financing, right, from like a hard money lender, you would want to write hard money loan, right? This period for the loan approval is a period that you really want to discuss with your buyer's lenders. I get many what I call cavalier lenders that tell you, no, just put a shorter time frame to make the offer more attractive. We'll get an extension later. I think it's a cavalier approach because the seller is not forced to give you an extension. So if you talk to the mortgage broker or the lender and they say, I think we can get you this loan approved in 20 days, then you can put 20 if you want. But do not count on the extension, especially when the market is really tight. Now, let's talk about what the contract says about actually getting approved for the loan. The loan approval is defined as requiring two things to be completed during the loan approval period. The first thing that must happen is that the buyer must obtain the loan approval of financing as is described in the contract. Now, 99.99% of loan approvals that are provided during the loan approval period are actually called conditional loan approvals. Conditional loan approvals. Conditional loan approvals are based on a series of conditions that the lender provides. Okay. That's weird because if one of those conditions does not get met before the end of the contract, and that is the reason that the loan does not close, there's a lot of different arguments as to why that may expose the buyer's deposit. Okay. So we'll talk a little bit more about that in a second. So the first thing you need to consider that you get a loan approval is the actual document of the bank. It used to be called the title commitment, the loan commitment, excuse me, the loan commitment. More and more banks nowadays call it the conditional loan approval. Now, the second thing that has to happen is a receipt of an appraisal satisfactory to the buyer's lender. Okay. This is really important because for many years, when this clause came out, we understood this clause to mean that the contract had an appraisal contingency. And I'm here to tell you, if you did not know, that the as-is 6 contract is not contingent upon the appraisal for the buyer. The appraisal is only for the lender's satisfaction. This was clarified by the Association of Realtors, the Florida Association of Realtors, in an article in June 2022 that was published by Meredith Cardoso, who at the time was the assistant counsel of Florida Realtors. And she writes very clearly, she says, let me be very clear, the FAR/BAR contracts do not contain a built-in appraisal to the purchase price contingency. If a buyer wants to ensure that the appraisal of the property matches the purchase price, they need to add the appraisal writer to the contract. Okay. Now, I have gotten into many conversations with agents about this clause because agents assume that because the appraisal language is in there, the contract is contingent. And this article very clearly states that it is not. That is why you will usually hear from me that you want to add the appraisal contingency. Okay. This appraisal contingency comes from the addenda at the back, right? The addenda at the back. So if you get an as-is contract and you look at one of the last pages, you're going to see this list of addenda. And this addenda F, appraisal contingency, that appraisal contingency is what you would need to include in the as-is contract, right? Over here. F, appraisal contingency. This F, appraisal contingency, says that the contract is contingent upon the buyer obtaining an appraisal before a certain date. So now we have another key time frame in the contract. This by default is 10 days prior to the closing date. Okay. And then it has to state what the value of the appraisal is going to be. And if you leave this blank, then you assume it's the purchase price. So according to that article from Florida Association of Realtors, if you want your buyer's money to be protected from an appraisal, you need to include this contingency. Okay. Now, I don't make up these rules. I did not write these clauses, and I am not an attorney, but this is kind of what it is. Now, to continue with paragraph 8b, financing, the paragraph says that the buyer has to use good faith and diligent effort. And it defines that it includes giving all documentation that the lender requires on time and paying for an appraisal and other fees. There are many buyers that apply to a loan and they just hold off on paying for the appraisal because they want to know other things about the property. And if you're going to make the contract contingent upon appraisal, even if you don't make the contract contingent upon appraisal, if the lender requires the appraisal, you have to pay for it in a timely manner so that you can ensure that the lender is going to go out and basically begin to work on the loan to get the appraisal back in a reasonable amount of time. Now, there have been some changes to the contract over the years, and one recent change is that the buyer now has till the very end of the loan approval period to advise the seller in writing that the loan was approved or conditionally approved. Before, you had the obligation to inform the seller immediately after doing it. The other thing is that the buyer is giving permission to other people in the transaction, like the mortgage broker and the lender, to disclose the status of the loan and release preliminary CDs to the seller and the listing agent. Okay. So this is a permission that the buyer is providing the seller. If the buyer is not able to obtain a loan approval, then the buyer can write to the seller and say, I have not gotten my loan approval, but I intend to move on from the loan approval period. Essentially, I am waiving my loan approval period because I'm confident that I'm going to get the loan. Of course, the buyer here is at risk because if the buyer doesn't close because the loan doesn't come through, they may lose their deposit, right? Now, if the buyer cannot obtain the loan and cannot meet the conditions of the conditional loan approval, the buyer can cancel the contract within the loan approval period by providing written notice. Let's say that the lender says, it's a condition of the loan for me to get an appraisal. The appraisal has not come back. Well, the responsible thing to do is to basically extend the loan approval period and ensure that in that extension, you can buy yourself the time to get, fully approved. If you do not get approved within this time frame, your obligation as a buyer is to communicate that to the seller. Okay? The contract does not require a loan denial. It simply requires that you notify the seller if you haven't been able to obtain it, and you can keep going as a cash deal or cancel the transaction. Okay? If the buyer does not provide written notice and they just stay silent, the contract says that the transaction will proceed as a cash transaction with no financing contingency. So essentially, the buyer has removed the financing contingency by not providing notice to the seller that they either got the loan or that they are going to move on as if they would have gotten the loan. If the buyer does not provide written notice, the seller can cancel the transaction within 3 days of the end of the loan approval period. And this has happened on several deals that I've been a part of where the buyer does not provide notice and the seller gets another offer. And they try and cancel the offer with the buyer within 3 days of the loan approval period. So if your buyers, if the buyers really want the property and they're going to move forward with the property either by obtaining the loan or because they think they have an alternative to close, they need to provide notice that they're going to move forward. Now, if the buyer moves on after the loan approval period and then the transaction does not close, the contract specifically says that the deposit is to be paid to the seller. The buyer loses their deposit unless the failure to close is due to a seller's default or to a property-related condition of the loan approval. Now, this issue of property-related conditions is kind of like a big Pandora's box, right? And one of the arguments that has been made in kind of closing circles is if condo issues are property-related conditions. So let's say that you get a conditional approval during the loan approval period. And one of those conditions is validating the condo's master insurance policy as part of the condo approval process. If the master insurance policy does not comply with the lender's requirements and you get denied the loan because of the condo's master insurance policy, the question is, can that be a property-related condition so that the buyer's deposit is protected? I've heard arguments on both sides. So we have recommended to buyers that they add an additional term to protect buyers in the case that the condo is not approved after the loan approval period is after the deadline of the loan approval period is passed. Okay. And it's important to note that appraisals are not covered under this clause. If you move past the loan approval period with a conditional loan approval, and then there's a reason you get the appraisal afterward, and the appraisal is not enough, the buyer could be in trouble with their deposit. Okay. Unless you put in the appraisal contingency. Unless you put in the appraisal contingency, and then you're protected. Now, I already talked about all of this. I'm sorry, I thought they were hidden. So in summary, the conditional loan approval can be conditioned if the conditional loan approval is conditioned upon an appraisal satisfactory for the lender, there is no loan approval if you haven't gotten it by the end of the loan approval period, right? So here you would actually need to negotiate an extension or get out of the deal. Okay. Now these timeframes can get really tricky, and your duty is to notify, right? We saw that the loan approval condition requires notification. You need to notify. So if you haven't gotten your financing in order for the buyer, you need to write to the listing agent that says we need an extension because we have not been able to obtain financing, and you need to use the association form to extend the loan approval period. Okay? All right, so we ended up talking about some other key timeframes here, right? We talked about these key timeframes, right? So now we're gonna go into the sixth paragraph of the contract and talk about occupancy and possession. Paragraph 6 basically says that unless this paragraph 6b is checked, the seller will provide possession to the buyer at closing, and the buyer can occupy the property. Okay. If 6b is checked, it means there's either a tenant on the property and a lease needs to be shown to the buyer, or the owner is going to stay in the property and they need to include a post-closing occupancy rider to the seller. Okay. This is a really important paragraph because it delineates what the obligations of the seller are to give possession to the buyer. Okay. It talks about, trash on the property. It talks about delivering keys. Okay. It also talks about if the buyer takes possession of the property before closing, maybe, it's very common that a buyer is having to move out of somewhere and they might go to an Airbnb for a couple of days. So they want to put, let's say, their things in the house while the closing occurs. That's really dangerous, right? Because the buyer is assuming all the risk and loss of property. So one time we had a buyer where they wanted to put a baby grand piano that had been inherited from their great grandfather. And they wanted to put it in the garage because it wouldn't fit into the storage as they were waiting for the closing. And the issue is, what happens, God forbid, if there would have been a fire in the property and that baby grand piano would have burned, right? The risk of that, of losing that item is on the buyer, right? Not on the seller. So we really usually don't love, these pre-occupancies and like the storage of things in the property before closing. If 6b is checked, you need to make sure, if you represent a buyer, to ask for a copy of the lease. If you're a listing agent, you need to have a copy of the lease ready to provide, because this paragraph says that the seller has 5 days after they receive the lease to review it and cancel the deal if they don't like the terms of the lease. Now, if the owner is the one who's going to stay in the property, we need to include, according to this last sentence, rider U post-closing occupancy agreement by the seller. I'll show you real quick. We're not going to review this whole addendum today, but this paragraph U gives you the post-closing occupancy by the seller. It tells you how long the seller can be there. It tells you who's going to pay for it, for that document, because it's a legal document that needs to be drafted. It says until when they can remain in the property, and it says what the monthly rent is going to be. Okay. There's a lot of people who put a monthly rent of 0. That's a business decision. But something that is not in this rider is a deposit. And we highly encourage that you negotiate a deposit for the post-closing occupancy with the seller for several reasons. First, if you need to evict the seller, you need money from somewhere. And second, when you do the walkthrough on a closing where the seller is going to stay in the property, you actually are not seeing the property empty. So there could be damages that you cannot see, that you'll only be able to see when they remove the furniture. And that's what the deposit is for. Okay. All right. Now let's talk about assignability. This is paragraph 7. Okay. Assignability allows the buyer on the contract to assign their right to this contract to another party, right? This is really common when the buyer as an individual wants to purchase a property under an LLC, and they're going to form the LLC after the contract is signed. And so the AVEX automatically checks off this second box, which allows the buyer to assign but not be released from liability, right? So this assignability is really important if your buyer wants to purchase under an entity name and you may not have the entity name, or the entity name is not ready by the time the buyer signs a contract, right? So if you remember, I said write in the individual's name as it appears on the ID and add the words and or assign. but then you need to make sure that you have the right to assign. This is why if the contract is assignable, you don't need an addendum to assign the contract. An addendum is an agreement between the buyer and the seller that changes the contract. But if it is assignable, then the seller already agreed to let the buyer assign it. So then you can do an assignment of contract, not an addendum, and you only need the buyer's signature. It's easier. Now let's talk about some additional terms. Remember, today we're talking about the basics, right? This is a very extensive contract, and we're going through basically only 30% of the contract. But this is the most basic things. So now I want to talk about the additional terms. The additional terms allows you to fill things in into paragraph 20. The AVIX proposes some baseline additional terms that includes compensation from the buyer to the broker. It includes additional language if the seller is a foreigner and FERPTA withholding applies. Number C is really important because it's saying that if there are open permits or violations, whether it belongs to the property or to the association, the seller has to take care of these before closing. Excuse me. And the reason this is really important is because if you do not add this language, remember it's an as-is contract, you won't be able to force the seller to take care of it. So if there is a violation in the municipality, that violation may not be a lien on the property, but the violation exists. And there may be a cost associated to eliminating that violation. If that is the case, this language protects the buyer. The buyer could say, you know what, I'm not going to close because this violation is really significant. Or this violation costs a lot of money. So in the additional terms, we're going to put additional language that is not in the contract where the buyer and the seller agree on something and they agree to make it part of the contract. It could be a credit at closing. It could be in a negotiation and a special assessment in addition to any one of these. Some of these terms are more common, right? This one, number C, is pretty common in the industry. This one, number A, it's pretty common in the industry. This one, number D, it's somewhat common that buyers ask for a seller's property disclosure. In other words, the seller's property disclosure is not a requirement of the as-is contract. So many brokers add the language. What are some less common additional terms? Well, a property related condition when you buy in a condo that says that if the condo is not approved by the lender, no matter when it happens, it's a property related condition that locks down the deposit for the buyer if the condo is not approved. FERP, the language on international closings, which we're going to do in part 2. Additional contingencies to protect against the lack of bank funding on investor deals, or exchange of keys if they're going to occur at another moment that is not the closing. Let's go into some of the key addenda. Paragraph 19 has this list of three columns for additional addenda. The addenda letters need to match the writers. It is quite common that I receive a contract that says that the contract says, let's say that that one of these addenda is included, right? Very common, let's say homeowners association B, but I get an addenda that is F. Why? Because they're taking it from another contract. So you just want to check that you're using the right addenda, okay? Let's talk about some of the most common addenda, right? Which is the condo rider. The condo rider is an extensive addendum. It's 3 pages long and it's been updated. Here you need to select if it is a condition of the condominium to be approved by the board, and if the association and the board have a right of first refusal. That exists in some boards where they want to give the other owners of the condo an opportunity to purchase first. It's not extremely common that it gets exercised, but it could get exercised. Now, if the association requires approval, the approval must be in the name of whoever is going to be on title. So if you're going to have an LLC on title, the approval must be in the name of the LLC. This is one of the most common things that will delay a closing, because the association might send the approval super late in the process. And if the contract got assigned and the assignment was not presented to the association will approve whoever did the application. So if you're going to represent a client at an association who is going to purchase under an LLC, especially if they're going to assign it, you have to make sure that the association approval is requested in the name of the title holder. Now, one of the really delicate clauses of this rider are the special assessments, right? This says that the seller is not aware of any special assessments that have been levied or that have been spoken about as an agenda or reported in the minutes of the board meeting of the association. So if the seller knows that there is a special assessment that has not been fully approved, but is being discussed, they really need to write it in here. They really need to write it in here. Now, if these special assessments are written up here and they can be paid in installments, then you guys can negotiate whether the buyer or the seller pay for that assessment. This is important because many associations who are not in the best financial footing are requiring that any assessments are paid at closing. They don't care who pays for it. What they care is that it gets paid at closing. So if they tell you there's a $10,000 assessment, and the buyer is going to pay for it, let's say the buyer agrees, the buyer may need to pay it at closing. Now, this clause protects the buyer because it says that that they would allow the buyer to pay in installments that special assessment. But then it turns out that the one who has to pay for it is the seller. The seller is going bananas. They're super upset because they thought they had negotiated that the buyer would pay for it, but the association does not allow it to be paid in installments. So now legally the seller is on the hook. I guarantee you this will cause an enormous amount of stress and delay to the transaction, right? So you really need to make sure that you're doing the proper disclosures and you're getting this right, okay? This paragraph asks for the condo docs to be delivered. What are the condo docs? The condo docs are, here you can see, copy of the declaration of condominium, articles of incorporation, bylaws and rules of the association, and a copy of the most recent year-end financial information, as well as the frequently asked questions and answers. These are documents that must be provided by the association. Many sellers keep their original documents, but it means the realtor has to help them update the most recent copy of the year-end financials, and these need to get delivered, right? This paragraph says they're going to be delivered, and usually this paragraph is accompanied by the buyer requesting a copy of the condo docs. Now, if you're a listing agent and you provide condo docs at the beginning of the transaction, make sure that you ask for a signed receipt of condo docs. This is a form that you can find in Avex, and you can find it, in Form Simplicity or whatever. This is an association form. Avex will help you fill this form out, and it says receipt of condo docs. So if you're a listing agent, make sure you get a receipt of condo docs whenever you finish delivering the condo docs. I'm going to skip and end today's session with a role of the realtor. Remember, there's going to be several parts to this training. So today's just, the basics. And so I wanted to wrap up these basics and leave time for questions. I wanted to talk about the role of the realtor. Okay. This is based a little bit on my experience after participating in more than 5,000 purchase and sale transactions with many realtors, many brokers across all the counties of Florida that we've worked in. The first is that the realtor has to help clients comply and understand the key dates in the contract. I am not saying that the realtor has to help the client understand the legal provisions of the contract. I'm saying you have to help them understand the key dates of the contract. All right. Realtors that are not organized will usually get this wrong. You have to be organized, right? You have to help your client be organized. Avex gives you a timeline of the key dates of the contract when you do your contracts on Avex. Folio Title will also send you the key dates of the contract in the very first email that you and your client get. You have to review these dates with the contract. You have to review them with your client. A client, let's say you have an international client that has funds overseas. If they have 3 days to make the deposit, they cannot initiate an international wire after 5 p.m. on the third day. They're never going to make it, right? So you have to coach them on these key dates. Help your clients understand their responsibilities of reading and complying with the contract, and recommend that they get independent legal advice. I would not provide legal advice or interpretation at any time, because I have seen too many things that look like black and white get interpreted in a different way by a different attorney or a different judge. Lastly, the realtor and the title company need to be aligned on the same team, right? The realtor and the title company are working to help this transaction close. You hear a lot of noise, and a lot of people try to put fear into the realtor because of the unknown. And they pressure you into giving certain responses that you may not need to give. So create an alliance with the title company. Choose the one that you like. We would love to be your title company for all of you. But on the deals that we work together, it's really, really important that that we talk and we have open dialogue. This is why we open the WhatsApp groups. This is why we have a support team for you. This is why we work with VIP support. That us as Folio Title have a direct line with VIP support to provide you, the agent, the best possible support, right? Create realistic expectations. This, to me, is the most important and most underappreciated role of the real estate agent. Once you sign the contract, the real estate agent is not in the driver's seat of the transaction. You want to feel like you are, but you're not. The title company is in the driver's seat of the transaction because the title company has to guide everybody to close. The title company has as a co-pilot the lender. Now, there are many lenders that try and drive the transaction, which is okay, but the lender cannot close until the title conditions are met. And the title conditions are met by the seller, not the title company. The seller meets the title conditions. The title company is trying to facilitate to clear those title conditions to provide the title insurance policy. So creating these realistic expectations is super important for the realtor. I'm going to give you an example. Lenders are usually ready before title companies because lenders do all their work in-house with the exception of the appraisal. Title companies do all their work with third parties. So if the lender tells the client, I'm going to be ready in 15 days, but the lender or the client does not inform the title company might be working with a time frame of 45 days because that's what the contract says. So it is the realtor plays a really important role in helping coordinate the parties and creating realistic expectations, right? I really want to encourage you guys to know the contract. I know for some of you it's boring. I know for some of you English is not your primary language. Please read the contract and highlight what you don't understand. And come to these sessions with questions that we can help you answer, go to your branch leaders, call me, send me a text message. Hey, I need help understanding this, so that we can help you understand the contract as well as possible. You can create addenda that require you to check the boxes and fill in the blanks, but realtors should not be creating addenda that is more than an extension, right? You should always consult an attorney and leave enough time for legal revisions, okay? And then try to communicate and facilitate contact between the parties, right? We talked about this one. So I just talked for an hour and a half, which is more than most people can handle. So I apologize for that. I'm gonna open it up to questions. Please raise your hand and open your mic, and I'll call on you. Sandra Batalla, please unmute yourself and happy to answer your question.
Gracias. Thank you, Ricardo. Ricardo, I have a listing right now, which is a land that you guys got the LLC for my clients from Chile. And they were going to build an apartment building. They're in the process of permits and all that, and they are pretty ahead of it, but they decided to sell the project. They're not going to build. It's taking too long for them.
Okay.
So today I received an LOI.
Mhm.
And from there, I don't know how to handle it because it's my first time I sell a project. I know LOIs are usually in commercial.
Yeah.
Is this a commercial? Is this a residential?
It's commercial. It's commercial. It's commercial vacant land, which is complex. I would 100% suggest that your sellers, in this case, hire an attorney to
Do you
walk
guys
them
do
through.
commercial?
Of course, Folio
Okay.
Title does residential and commercial closings.
Okay.
We cannot legally represent anybody. So Nelson Teresito is an attorney. He gets hired as an attorney to represent clients. Now, if your clients decide that Folio should do the closing, then Folio can do the closing, but because it's commercial, we bring in the attorney to accompany the clients.
Okay, and so in this case, then the seller is the one that provides the contract.
I mean, usually the buyer is going to send you the offer. What you need to find out is who is going to do the closing and who's going to pay for it, right? Because
Okay.
your sellers may want to control the transaction because of the nature of the transaction. And so they might choose the closing agent and pay for the title insurance policy, and they can negotiate it in the price of the property, which I can talk to you about offline. Okay.
Okay, perfect.
I'm gonna answer Eduardo Sanchez, and then I'm gonna answer some questions in the chat. Eduardo, hello.
Hey, Enrique, how are you? Good morning.
Good morning.
So my question is, as you said previously, the seller's property disclosure is not part of the ASIS contract, and that's why it's not in the addenda list.
Correct.
However, when you go to the seller's property disclosure, it says that Florida law requires the seller to provide a disclosure. So how do you reconcile that when many times when you place an offer and then you request this seller property disclosure, say, oh no, the seller never occupied the property, which has nothing to do with the disclosure, because actually the first question in the disclosure, it says if it's owner occupied or tenant occupied or unoccupied.
Yeah.
So how do you reconcile this in terms of the negotiation when the seller broker, basically the agent, comes with this answer and they don't actually read what the paperwork says?
So as you know, I'm not an attorney, so I'm going to tell you why I think that this is happening.
Okay.
The form of the seller's property disclosure is not required, but the as-is contract does have contractual obligations for certain disclosures from the sellers. For example, the as-is contract obligates the sellers to disclose if they know of any work that was done without permits. What is not required by Florida law is the form. The form is created by Florida Realtors Association to facilitate a disclosure, okay? in my personal opinion, and again, I'm not an attorney, but in my personal opinion, it makes no sense that a seller would not provide a written seller's property disclosure, and I'll tell you why. Even if the seller does not live in the property, they can say that they don't know about a lot of these things. But even if you
course.
haven't lived in the property, there are things that you're going to know about. For example, if there is a leak in the property, your tenant is going to tell you.
Mhm.
If there are termites in the property, your tenant is not going to pay for termite pest control. The owner, the landlord is going to pay for tenant pest control. So even though they've never lived in the property, they can answer don't know to a lot of questions, but there's a lot of questions that they do know. So, not only that, if they provide a written property disclosure, everything they know is supposedly on that form. So unless they're lying, which right now we have a case where there's a seller's property disclosure where the sellers lied on the property disclosure, unless they're lying, they basically have no more liability after closing. They told you everything they know. And the as-is contract is pretty clear that the buyer has to do their due diligence. The buyer has to do their due diligence because it is as is. So
Okay.
I think that's the reconciliation of why you see that it says Florida law requires a disclosure.
Yeah, but if it's not done, let's say we are not talking about technicalities about, well, this is not the form, or the form was not delivered, but they still have the obligation to disclose, right?
The issue is what do they have to, what is the what disclosure needs to be provided?
Well, any facts that affects
Material,
materially the value
right.
of the property.
And the as-is contract says that, right? So the form
Mm-hmm.
is just a suggestion of what should be disclosed, but the sellers
Okay.
could say, listen, I'm disclosing to you that I never lived there. I didn't do work without permits, and any repairs that need to be made that affect the value of the property, you are going to you discover in the inspection period, and that's my disclosure.
Mhm.
Right? And
Okay.
so it's kind of a play on words, but
Yeah.
the seller's disclosure form is not a legal form. It's a Florida Association form that has legal implications, right? So I think
Okay.
that's where the disconnect is. I am always very unhappy when I hear listing agents saying, no, they refuse to provide the form because they've never lived there. I've never thought that was a great answer, but I guess the seller
Yeah.
has the right to not fill out the form.
Correct. Okay.
Okay.
Thank you.
Let me go into the chat. There were some good questions here. Let me go first to Monica. For the assignability clause, is it only for LLCs or can you assign to another buyer? You can assign to another buyer. You decide to who you assign it to, right? Any you decide. If you don't include and or assigns and you check paragraph 7, can we still assign? Yes, you can. If the contract is assignable, yes, you can. So thank you for that question, Monica.
Thank you. Thank you.
Okay, great. Let's see. Richard Candia. The effective date being day 0 is super helpful. Thank you. I think so too. Can the seller call the lender and ask about the status? Yes. The seller or the listing agent have the opportunity to call the lender, and according to the contract, the lender needs to provide an update. What proof can the seller ask for to ensure buyer cannot obtain the loan in a timely manner? That's a tricky question. Richard loves tricky questions. That's a tricky question because at that point, if the seller is doubting or disputing that the buyer gave their best effort in a timely manner, technically a seller's attorney could request evidence that things were provided in a timely manner, right? So I've been involved in several deals where Latin American investor buyers send information that was requested from the lender. They send it super late in the process. And there are seller attorneys that have said, you know what, this does not seem to be in a timely manner. We believe that your buyer is not acting in good faith and should lose the deposit. And so then you get into you get into a contract dispute. So, you want to try to avoid those as much as possible. yes, this presentation will be shared with the video. Please make sure that you guys fill out this form with a QR code. If you don't, we'll have to upload your names manually, which Avanti will provide, but if you do, it would be much, much easier. Let's move on. Can you please email the presentation? Yes, please make sure, Stacy, that you scan this QR code. And there you can leave your information, but if you cannot for any reason, I will make sure that you are added to the list, okay? All right, let me see any other questions. Any other final questions or comments? This is part one, this is the basics, and I know that for many of you, this could seem a little overwhelming, so, you know, this is extensive. Sandra, I think you have another question? Sandra, you can unmute yourself?
Yes, I
Yeah.
do.
Tell me.
Ricardo, why isn't it a good idea to always make the contracts assignable? If it's not assignable at the end, it doesn't matter, but you have that window open.
I think it's a great idea to use the second one, which is may assign but not be released.
You give yourself more options, basically. If you
Yeah.
change your mind, your client change your mind, and then they decide to open an LC and you don't do
Yeah.
it, then they won't be able to do
Exactly.
it unless,
Yeah.
yeah.
That's my point. So
But-
we should usually recommend
Yeah,
them. Let's
always.
keep it
Yeah.
assigned.
Yeah,
Always.
so I'll tell you a couple of things. I've worked with many brokers and listing agents that are extremely forceful about the contract not being assignable, and I never understood it. I've asked around to a lot of different places. Those that know me know that I'm a curious person. Eventually, I kind of got a lead as to where this was coming from. Apparently, if you train on the contract in the Association of Realtors, they usually do examples where individuals are purchasing for their homestead property. And if you are an individual purchasing for your homestead property, it's 99% certain that you will not be able to close in another name than your individual name. So all the defaults in the association are may not assign. And so I don't know if that's true or not. That's complete, speculation and conspiracy theory on my part. But I do believe that a lot of agents have not been well trained on what it means to assign. Because for a seller, if you allow the buyer to assign the contract, but the original buyer is still responsible for the contract, I really don't see the risk. Again, I am not an attorney, but if I'm the buyer, like Eduardo said, you want maximum flexibility. Now,
Yeah.
you should know that if you're purchasing a homestead property as an individual, you probably will need to close in your individual name. So if you put may assign and not be released, and the listing agent is fighting you over that, you may not be able to close in another name either. So it may not be worth the fight. That is kind of a case by case basis, right?
Mm-hmm. Okay.
Last question. If the property is 120,000 is a great question. If the property is 120,000 and if the property is 100,000, the contract, and it appraises for 120, the contract is contingent on the lender and the buyer. So I assume that this question is, what happens if the appraisal is higher than the purchase price? What happens is basically the property appraises, but the purchase price isn't going to change. So if the buyer closes that property, they essentially have a property that they're buying that's worth more than what they're paying for it, according to the bank. So the buyer is kind of winning in that case. But I get questions a lot if the seller can then change the price. The seller can't change the price either way, right? If there's a very common clause that says, well, the buyer is willing to pay X amount over the appraisal value, right? So, let's say the purchase price is 100,000 and the buyer is going to pay 5,000 above the appraisal value. Okay, the buyer is going to pay 100,000 if the property appraises at $95,000 or more, right? Because you usually limit it to the purchase price. So the buyer's like, okay, if I pay $5,000 more above the appraisal and the appraisal comes in at 80,000, why does the purchase price not 85,000? And the answer is because the seller didn't agree to 85,000. The seller agreed to 100,000. So if you do a contract for 100, if you're willing to pay 5,000 above, and the appraisal comes in at 80, the buyer is willing to offer 85, but the seller needs to accept an addendum lowering the price to 85, or the seller does not need to, the seller's not forced to reduce the price. As is the opposite. If it appraises for more than the purchase price, the buyer is not obligated to pay the seller more. Okay. Okay, boys and girls, I hope you guys enjoyed today's session. This was the basics. Thank you for joining me and for listening to my voice for so long, which is hard. We will send around the video. Surprise, surprise, next Thursday at 11, you will have the chance to listen to me talk for another hour and a half in Spanish. And we're going to do this presentation in Spanish. So tell your friends, and I hope to see everybody soon. If you guys want to leave any comments before you leave, please leave them in the chat. They're really, really helpful to me. If you have any feedback, and if you just want to send me a WhatsApp and give me feedback on the presentation, I would really appreciate it, because we have been trying to evolve this presentation. I just put my cell phone in the chat, so feel free to please send a commentary. The second part of this presentation is not planned, but is likely going to be late May or early August or early June. But there's going to be a second part in English, and then there's going to be a first and a second part in Spanish. Okay. Thank you, everybody. Have a wonderful day.
Gracias.